Well, today we're talking about the Ministry of Justice's report on assessing risk of harm to children and parents in private law children cases. This is the front page of their report, and as you'll see, it's headed with the Crown insignia, the Ministry of Justice title, and this was published in June 2020. And we're lucky enough to have a chance to talk to Terry White, who's got a lot of experience of the negotiating with organisations that put out misleading reports. And I think we'll leave it to Terry to explain his background and what he's commenting on. But he's pursuing a judicial review of this report from the Ministry of Justice because of the deep and serious criticisms that he has to make of it.
And I think it's a very interesting take on this report. I think a lot of people will be interested to hear him talk.
Yeah, you need to listen to this. This is half an hour, and I think you'll find it really an insight into how the Ministry of Justice is behaving, particularly with a view to anybody's personal experience in private law, family court.
In my former life, I was an oil and gas banker and worked in financing the extractive industries and emerging markets for some 25 years now. And I've done transactions from Russia to Nigeria and Angola, and from Papua New Guinea to Colombia. So I've seen a fair number of some of the worst jurisdictions and how they operate.
Yes.
And gotten familiar with some of the tactics that are employed by these jurisdictions to achieve their political goals whilst maintaining a facade of respectability.
Yeah. So what do you see happening? What are the techniques?
Well, when I saw, as I've been looking at this report, it seems to remind me mainly of the techniques that have been applied in the former Soviet Union, particularly by the oligarchs and enriching themselves through perestroika, and also in the state expropriation of assets. And in all of these matters, the overriding objective is to create this veneer of respectability. On the surface, if you glance quickly, all the boxes are ticked. But if you drill down through the veneer and actually look at it, you can see that it's actually rotten chipboard behind it. But that takes some time and effort, and that's not something that most people would do when you had the stamp, the insignia of the state, a trusted state like the United Kingdom, on the front cover as it is. Most people will take what they see at its word.
I think most people would find what you're saying horrifying as well, Terry, because of the comparison.
So the comparison. So the parallels are what?
Well, the first thing that annoyed me, I guess, was the way that this was a 400-page data dump on one day with a press release saying the implementation plan had already started.
Yeah.
That's not something that's peculiar to emerging markets. I mean, that's something that you see as a gameplay in a lot of legal situations, but it is something that you do see a lot. And essentially what that does is puts you on the back foot. You're playing catch up. This is now March. This was reported in June, and we're still waiting to get into the Court of Appeal to have it heard.
Yeah.
So
to have your objections heard, am I right?
Yeah,
to
have any sort of formal scrutiny of what they've actually done here.
Yeah.
And in the meantime, of course, this report has been relied upon in the House of Lords and in the Court of Appeal in another case. And so the traction is already underway, and we're in the unenviable position of having to try and claw it back, having to try and pull it back and say, hang on, guys, no, let's look at this carefully before you run away with it.
But run away it has.
Yeah. So when I first looked at the report, I noticed that the foundational evidence, the evidence pack that they've used, essentially was a survey that they undertook themselves. As you know, the actual cases, there's a lot of confidentiality around these around family court. So the government, peculiar to the UK, the government is a very unique position of power vis-a-vis the public. The government controls all of this information. There is no way that you can challenge it. There can't be a challenger to it because you and I can't access the data to say, hang on, guys, you're wrong here. So the government has, in this circumstance, a special responsibility to make sure that it's gone through the correct processes before it starts telling people what's happened, to make sure its data is correct. And what this reminds me of is when you're dealing with the former Soviet Union in particular, you come across these state secrets. They have special legislation for state secrets. And yeah, it's just impervious. You can't get a view on it, and you're putting yourself solely in the hands of the government to provide you with the information, and you are on very shaky ground because there's no control over what the government will actually give you or choose to give you.
Yeah.
So I was struck in this case that there wasn't any reference to any real data at all. The Ministry of Justice actually sits on or has access to a trove of data. It has all this family court information. It has also the probation service and the criminal court data to access. And none of that is in this report that's ostensibly looking at assessing the risk of harm.
Yeah.
And one would imagine that if you're assessing risk of harm, you would actually your first port of call would be to say, is there any harm? And actually have a look at the data to see what is actually happening. But instead, they undertook this process where they went out to the public for qualitative, or what they might call qualitative data. The second thing that struck me is that this search for qualitative data didn't even meet the standards of a poll. There were no controls, no visible controls over this data gathering process at all. There was no verification of people's accounts.
So it's anecdote, isn't it, really?
Well,
not data at all.
It's anecdote. You're asking people who have lost their cases in court already. So they've already had their positions looked at, and the court has decided that there's something not quite kosher about what these people are telling us, and made a decision against them. So even the people that they're sourcing information from are inherently unreliable. And of course, it's a voluntary response as well. So in any data gathering process, if you're looking for voluntary responses, you're going to get the people who are going to complain in the first instance. So it doesn't give you a picture of what's actually going on.
Yeah, yeah.
So what was wrong with this actual data set? You can see quite plainly that there was a 4-to-1 ratio of women responses to male responses. And in private court, of course, you have a mother and a father in all cases, and there's two sides to every story. So if you are actually getting 4 times as many responses from one set where it should be 50-50, it's inherently unrepresentative. And as an analogy, you can imagine that if I said to you, well, we've taken a poll of 100 people, 80% UKIP and 20% Remain, and we've discovered that there's a problem with immigration. You wouldn't accept that.
It's kind of transparent, isn't it?
Yeah.
Put like that, I think anybody can get the point.
Yeah. The second problem is the verification. There's no verification of these responses. So we don't know whether any of these people actually even went to court, right? When you couple that with the advocates on the panel and the apparent political leanings of the authors, and you match that to the 4-to-1 response ratio, there's a particular risk that you're getting a lot of responses from people who have who are just making it up, making the whole thing up from scratch for political purposes. So there's no control to check for that.
So what's your comment about the panel?
The panel itself has a weighting that has a lot of compromised positions in it. For instance, there are pronounced feminists in the panel. The panel mix is 10 women and two gentlemen, and although that shouldn't mean anything, it's a little bit like a black man being tried by an all-white jury. There's an optical problem with that. The panel membership includes the declared feminists. It includes Women's Aid, 2 representatives from Women's Aid. And Women's Aid, basically, if there was no problem with domestic abuse, Women's Aid wouldn't have a justification to exist. Mm-hmm. You had the business development director of Respect. Now, why a business development director would be a panel of an expert is beyond me. But that position is also compromised. And there is also a compromise in Mr. Justice Cobb's presence because he was so influential in developing Practice Direction 12J. He has, or he might be, disinclined to pursue avenues of investigation which would call into question the efficacy of that practice direction. Practice Direction 12J is the practice direction which governs how the courts manage allegations of domestic abuse.
Yeah.
So altogether, the government has mistaken vested interests for expertise, and they're not the same thing.
Yes.
What struck me about the panel was the complete absence of any technical competency, dealing with issues of intense psychological complexity, and we're dealing with complex issues, complex multivariate drivers of criminology that requires some pretty expert statistical analysis. And there wasn't anyone on the panel who was competent in that regard. The panel was almost entirely lawyers. The Ministry of Justice has lawyers. I can't see why they'd have to go outside that organisation to get more lawyering on the panel. The panel of experts should be the panel of people who with expertise in the fields that they're looking for, people with expertise in criminology, people with expertise in child development psychology, people with expertise in statistics and mathematical analysis, and that's just not present.
You have got the authors, though. It's another group, isn't it? You have a panel, and then you have authors.
The authors were part of the panel. The authors, of course, were all doctorates in law. None of them had technical expertise in the issues that I mentioned, or in the areas that I mentioned.
Right.
So although it looks like you've got all these doctors and professors and whatnot from various universities, they're all basically within the same field. You don't have that cross-fertilization between fields that would actually provide for a balanced, holistic view of the situation. And then, of course, you do have the presence of advocacies or advocates in the panel and amongst the author group. I'm particularly concerned about the presence of feminists. I mean, and with the literature review author, you wouldn't invite, a white supremacist to do your research on race relations. You just would not include someone who has got a stated vested position. One side, it shouldn't be a gendered issue, but there is undoubtedly a feminist there is a cross-gender conversation to be had here, and you should not have, ideally, people who have already stated their positions in this. There's an element of apparent bias about the composition of the panel, which calls it into question.
You commented on the literature review as well. There is a review of the literature.
Yeah, so the report, as we've put it forward, was the 3 documents and the press release that came out on the same day. So there was a literature review, there was a final report that was authored by the panel, and there was the implementation plan, which is a direct product of the Ministry of Justice.
Yeah.
And what happened is the literature review was commissioned by the panel itself. So the Ministry of Justice commissioned the
Right.
panel, and the panel commissioned the literature review, and they all
Right.
bootstrap in together into the policy document at the end.
Right.
What the government is arguing in its submissions in our judicial review is that none of this is any, it's not me, Gov, it's the panel in the literature review, and it's not part of the Ministry of Justice. So every time that everyone's referring to this Ministry of Justice report, they're actually misnomering it according to the Ministry of Justice.
Except it's chaired by somebody from the Ministry of
It's
Justice.
it's chaired from the Ministry of Justice, but the Ministry of Justice is saying that this is actually a panel, and any problems that you have with this panel is nothing to do with us.
I don't know why you'd call it a Ministry of Justice report then.
And somebody
And they've
selected
done
the
that,
panel.
haven't
They don't.
Pardon?
No.
They don't call it that.
No. They call it the report of the panel.
But I thought the Ministry of Justice was the title was on the front page. Have
It
I?
Yes.
It is. Yeah. So
That's and it stands with the insignia of the crown as well.
Yes.
And that's one of my biggest concerns.
it's misleading then.
I believe so. Yeah, I believe it misleads the public, and it's misled the Parliament, and it's misled the Court of Appeal as well. If I can just circle back on the survey, the problems with the survey, because we didn't actually address the biggest problem with that, which is that we can't check against what they're telling us. These survey responses, we can't check it against what has actually happened. The court, of course, is in the best position in each individual case to make a determination of the truth. I mean, it's not ideal, but certainly it's much better than us going by what one side said. As I mentioned, these people have likely already lost their cases in court. Chances are they have been uncovered to be less than entirely truthful about their allegations. And so it immediately raises a question, why would anyone believe them now about what they're telling us? So there's no, effectively, because this is so flawed in its approach, and the report actually says that it's flawed. The report actually says, this alone is not sufficient, but the report is wrong to call what they've done qualitative research, because it doesn't even meet those standards.
Are you saying that people who succeeded in their court case probably wouldn't have offered any evidence? Is that it's the aggrieved who would self-select to be part of this group?
I'd say so, especially considering the confidentiality restrictions around it. There's no reason why you'd take the risk of exposing yourself to the other side again.
Yeah, especially if you walked away happy from a court hearing, you're probably not going to go and seek out the Ministry of Justice panel to talk about it.
No, and certainly not if you're a man who's managed to escape false allegations. It's quite the mill that you have to go through, and you certainly feel like sitting in the corner and licking your wounds for a while after that.
So you're going to get the most histrionic, attention-seeking, and aggrieved people seeking out the opportunity to talk about it.
Absolutely, yeah. Absolutely.
And as you say, they may not tell the truth even. They may just make it up.
No.
Nobody knows if they're making it up or not.
No, there's no control in this process at all, and that's what I'm saying. It doesn't even meet the standards of qualitative data. I've referred to it as indicia.
So if that chap, Nick, for example, who was so famous in the last couple of years, Carl Beach, inventing allegations, if he wanted to interest himself in this subject, he could easily have given evidence about his experience, and nobody would have known whether he had made it all up or whether it was true or not, or whether he'd even been to court. Okay.
I still think that there are people who genuinely do have, they have been treated badly. They genuinely have been treated badly, who will see this report as, giving them a bit more power, giving them more say in what might happen, because the situation or the circumstances are bad. There are a lot of people who have genuine concerns, I think. Are you questioning that, Terry?
No, I'm saying that the process should have been undertaken in such a way that they would have, for instance, if they had actually been approached, if someone had pulled a case file, determined that what had happened in the hearing, and then gone and talked to the people about how they feel. I mean, it's not to say that people's feelings are irrelevant.
No.
But you've got to have the control to say that this is actually a genuine story and it matches in with some of the facts that we've seen. I mean, you might have a different view of how the court read the facts or whatever,
Sure.
and that should come out. But at least you can say that this happened and this was found.
Because the danger is that you objecting to this report looks like objecting to the idea that domestic abuse is a bad thing. That you can find yourself in a false position of apparently arguing that there's no such problem as domestic abuse and that we shouldn't be worrying about it. And that's not the point, is it?
No. The point is, and I firmly believe that false allegations are a form of domestic abuse in and of themselves.
Yeah.
It falls under controlling and coercive behaviour. And if you have a look at the Home Office guidance on controlling coercive behaviour that they brought out in 2015, Section 32 of memorised, the second bullet point actually says, as offender tactic, it actually says that that causing vexation by false allegations or vexatious allegations is a tactic that is employed by coercive and controlling people, and is a coercive controlling tactic that's undertaken. So, taking a holistic view of it, you would be looking at both sides of that. That if you take domestic abuse seriously, if you actually are concerned about controlling and coercive behaviour, you'd be looking as heavily and as strongly at the false allegations as much as the allegations themselves.
And maybe we have to make it so plain and boringly straightforward that none of us are defending domestic abuse. We all know that it's a huge problem. None of us are defending false allegations because we know that's a huge problem, although that's disputed about whether it's a huge problem or not.
Yeah, well, exactly. That is my dispute, especially in private law proceedings, because what we're actually looking at here is what the impact of private law proceedings are, whether or not once proceedings have started, domestic abuse is occurring.
Well, you get some legal aid if domestic abuse has occurred. If you allege domestic abuse, there's a huge incentive because legal aid funding can then kick in.
Yeah. There's been some studies showing that there has been a reaction in the number of applications that are made, particularly in the non-molestation. The path seems to be, because you can get an ex parte order, which means an order where the other party is not invited to attend court. You can get an ex parte order under non-molestation. So you do that, and then that would give you access to the legal aid to the family court. It seems to be a pattern that applies. And of course, the false allegations to police, having the guy arrested and everything, that's all problematic.
And there's a real problem doing a proper risk assessment within private law because of the funding issues. How are you going to spend the time and money to get the expertise, if it's even justified, to decide, to help the judge decide or help the court decide what may in fact be the truth?
Yes. Well, the thing is, the first point that you have to remember, that the family court is about the welfare of the child. And the relationship of domestic abuse to the welfare of the child is only if that impacts the child. So the first test for the court is to say, is this or is this not relevant to the harm to the child? So, for instance, sending the mum a rude text message every now and then should not be brought into account. It should be controlled, and certainly the family court can say, stop doing that or you're prohibited from doing that anymore. But that does not necessarily impact on the child. It might have an impact vicariously through the effect it has on the mother.
Of course.
And this is something that a proper report on assessing risk of harm should have looked at, right? It should have gone through and with the benefit of the expertise of the child development psychologists and others, determined whether and to what extent, using a multivariate longitudinal analysis of the outcomes on children, what has been and is the effect of domestic abuse upon them, how that compares with the benefits of maintaining direct contact, and what are the drivers, etc., of these behaviours, and importantly, do they actually stop? Because many of these things, many of these events seem to arise at or around the point of separation. Extremely stressful time, the relationship's falling apart, and someone acts out in some way that they later regret.
Yeah.
And that is not how they normally are, and that's not how they would parent. And I think we need to make a distinction, or at least determine where the distinction is between what is relevant to the child's welfare and what isn't relevant to the child's welfare. And particularly looking at those acts which occur around separation, where people are being horrible to each other in so many different ways.
Well, it's a very interesting issue, because both Jill and I have mainly worked in the area of care proceedings, public law,
Yes.
where there is an issue about threshold, and there has to be a
Yes.
decision made. Does what's happened to
Significant harm.
the children, have they suffered significant harm, or are they at risk of suffering significant harm? There is, but if it doesn't meet the threshold, there's no proceedings.
Yes.
So in private law, you can have as much proceeding as you like without anybody establishing whether the threshold's been reached. People can
That's
keep
very
on
true.
making allegations. It can drag through the courts for years, on and off, with different issues being raised. Nobody ever establishing whether a threshold's been reached to harm the children.
That's a very good observation. That's a real dichotomy between the two streams of family law.
And they're both going on at the same time, which is extraordinary.
Well, some of the cases that I've been hearing about, Terry, I genuinely believe that they should have the same attention as care proceedings, because
Yes.
it's impossible to sort it out as private law proceedings.
And the children are caught up in the most
these
terrible
children
circumstances.
are in circumstances which are just as bad as a lot of the children that I've represented in care proceedings.
Yeah.
I
Well,
mean, the emotional harm levels are very high from my perspective, but it's not. Nobody seems to think, it's just treated differently. Nobody seems to think, well, this is very similar to what we're doing in care proceedings, which it is.
And the manoeuvres that happen around contact can leave some parents completely excluded, or at least
In
pushed
private
out of
law.
contact,
In
and
private law.
in private law,
Yeah.
in a way which would never happen in public law, because there's no independent representative for the child who is going to ensure that the child's relationships
Well, there are
with
some in private law proceedings, but
if you can get a guardian appointed.
yeah,
it's not common. But there are
Well-
grandparents and parents and uncles and aunts who are being
whole families
affected.
are being excluded,
Yeah.
definitely,
Yeah.
from a continuous relationship with children.
Can you tell us, Terry, what you're doing? You're seeking a judicial review of
That's right. Yeah, of the processes that were undertaken. My concern, it's impossible to take on what the conclusions are because the data is confidential.
Yeah.
But the processes that have been undertaken in formulating this report and producing it mean that it should never have been published. The government, I'm saying, has a special duty in such circumstances, arising from Article 8, which is the respect for family life,
Yeah.
but also arising from the Constitutional Reform Act, to ensure, especially in these circumstances where it is the only source of information, that the information it produces meets at least a minimal standard of care and diligence before they throw it out there.
And what support are you getting? What kind of what kind of help are you getting, or what kind of support and encouragement are you getting?
Well, it seems that I'm coming at this mainly from the men's group. So there's no money. There's no money in this. There's no money in family court anyway, and there's certainly no money in taking on the government. There's lots of moral support out there.
You need as much moral support as you can get.
Yeah, not a lot of physical support.
Presumably, though, you're going to get a lot of stick because it will be interpreted by some as, well, you obviously are domestic abuse denier. I can imagine that potentially from
Easy
the
to
feminists.
label it as that.
Have you had any of that yet, Terry? Or
No. I'm still far under the radar yet. Maybe your podcast will change things, and I'll get harassed subsequently. But
Let's hope so. It'll be a sign of success. A problem you want to have. I'm sure there are some trolls out there just waiting. Okay, well, look, Terry, I think we need to stop there.
That's a shame. Okay.
Well, no, we don't. But I think we. I mean, if we're going to talk more, we would have to talk again. I think.
Okay.
would you do again? Would you talk
Yes,
again?
of
It would be
course, yeah.
great.
We'd be. Yeah, go on.
I feel that I didn't cover quite some of the linguistic tricks, and they're quite important. What's been done here, for instance, the conflation of alleged abusers and actual abusers, and the swapping of the term. They say there's no automatic right to contact, and it should be there's no absolute right to contact, and exactly what that means.
Yes. Well, it'd be great to unpick that.
Yeah.
I think we've got enough for people to be digesting.
It's kind of a taster, really, I think, from my perspective of what you're doing and what you're thinking. And I think a lot of people will be interested. So if we can get people interested and you come back, that would be brilliant.
That'd be lovely.
We'd love to talk to you.
Well, what do you make of that?
I thought it was really interesting. I knew a lot of what he was going to say already, of course, because we'd spoken to him. I do think, though, that we're going to find that the audience is probably split between those who really are very interested in what he's saying and
people who want to find fault with it?
No, they feel he's speaking for them, and I think then we're going to have a lot of women who perhaps think the opposite, and I think that's a shame.
There's going to be a gendered response.
I do.
Like women will think it's like
women will
denying
think
domestic abuse.
that, yes.
Which it isn't.
No, he isn't saying that. But I think because he's critical of the comments that are put in the Ministry of Justice report from individuals, he's questioning whether they're truthful or not.
Well, he's critical of the origin of them, how they've been
yes.
canvassed and who these people are, and
yes.
the lack of any scientific rigour in selecting the people that they've spoken to.
But when we did our first podcast about the report, I'd chosen some of those comments which we went through, and I chose them because I thought that they were, at least I didn't at the time think that, well, could this be a made up comment, but what I thought was, well, these are the kinds of things that I've heard.
Yes, but I don't think that the comments that they've published are necessarily made up.
No.
It's that there's no scientific rigour in explaining how they have obtained comments in general.
Yes.
They've obviously picked comments which have got credibility, and they have. They're very convincing.
But I think it would be possible to suggest that he's just, trying to let's ignore it totally, and he isn't doing that.
Well, nobody wants to deny the importance of domestic abuse.
No.
I mean, we've come across so many cases where women have a terrible experience because of the coercive control that they're under. And
they need a lot of help and support.
Yeah.
So, we're not trying to take away from that. But there's another side to the story in terms of the false allegations.
Yes.
And he's trying to make that more important on the agenda than it seems to be.
Well, and just criticise the lack of rigour in the Ministry of Justice's approach, which, they even deny that this is their report now, which is kind of amazing.
And we should all want this to be truthful and something to rely on, because you can get better outcomes then.
Yes.